Hey, good afternoon, good Monday. Welcome to Deeping Sources Privacy of Me podcast and videocast. This is Monday, February the 6th, 2023, and I'm recording this as both a videocast and a podcast. They will be released separately, so the podcast will be on the Deeping Source podcast site, which is deepingsource.io/podcast. And the video cast will be on our YouTube channel, which you can also find simply by visiting deepingsource.io. So this is, as I said, our second full podcast. And as we get into privacy and data privacy and video biometric privacy and all these other exciting things, I thought it would be a good opportunity for us to discuss GDPR. Now, GDPR does not directly affect the United States. It has some sidebar effects with GDPR covered individuals in the United States. And of course, if you have a business that has offices in a GDPR country, you have legal obligations to meet. But this is more an explanation of what it is, simply because it has informed the California CCPA and the Illinois Biometric Act and others, bit of a model for how US states and potentially even the federal government is going to move forward with overall data privacy rules. Now, there are certainly going to be states that resist any sort of a move towards a more wholesome data privacy act, whereas there will be other ones who go the opposite way and lock more or less everything down. It's really, really too early to tell, and it's really hard to say. And later in our podcasting episodes, we're going to be joined by a gentleman named Blake Glatstein, who is a data privacy lawyer. And he will echo and dig into a point I'll make now. Laws are created multiple ways, but one of the ways is through case law. And it's really more of an interpretation of different parts of the law, but not important. What is important is to realize that we have very, very little case law around video biometrics, video data privacy, etc. So it's kind of being made up as we go along. And as we all know, based on the last few years, and more in our own country, that can be a good or a bad thing. So let's have a look at GDPR just to get a broad overview understanding of what it is and how it's been applied. We'll look at a specific case. And as we move forward in the podcasts, we will bring GDPR into a closer look at affecting the United States, us. So, what is GDPR? So, GDPR, General Data Protection Regulation. First and foremost, the goal of GDPR is to provide data protection for citizens in the EU because it covers all EU countries plus 3 more. And interestingly, it also provides a way to be forgotten. This is a key part of what GDPR does. It allows a person to be forgotten. What does that mean? Exactly what it sounds like. It allows a person to go to a country or whatever, within their country, I should say. It allows a person to go to a business and say, cut me out. I want you to delete everything I have. Tell me everyone you've given it to, et cetera, because I want to be forgotten. I want to be off the books. That's a big part of what GDPR does. Okay. Now, GDPR has 7 pillars, right? Those 7 pillars, that's better. GDPR has 7 pillars: fairness, lawfulness, and transparency, data minimization, confidentiality and integrity, accuracy, purpose limitation, storage limitation, and accountability. Let's take a look at each one of those. Within GDPR and those 7 pillars, we do have a slight breakdown in the definition of data. You'll see on the left, we have names, social security number, or those types of numbers, emails, credit cards, usernames, and IP addresses. Special category data, information that can also reveal race and ethnicity, religion, anything that falls into health, genetic information, or biometric information. And you may recall from a earlier podcast, the biometric information, hand, fingerprint, facial recognition, gait analysis, voice printing, that sort of thing. Any data that can be used to discover a person's personal information is subject to GDPR. Bear in mind, there are always going to be exceptions to rules. For example, anything deemed to be in the national security interest of a country, anything used in certain types of research, although it does have protection requirements. And each one of the GDPR signatory countries does have the right to have their own national rules supersede the GDPR, as long as those rules don't invalidate GDPR. So, pillar number 1, fairness, lawfulness, and transparency. Fairness, lawfulness, and transparency. So, this is obviously pulled as a summary from GDPR. Personal data processed lawfully, fairly, in a transparent manner in relation to the data subject. So, what does it mean? You got to get consent from the user to collect their data. You are allowed to do it if it's part of a contract. You're allowed to do it if it's necessary for some sort of legal obligation. You're allowed to do it, and do it, by the way, collecting the data, for protecting the vital interests of a person, or it's a public task done in the public interest. You better be able to prove you have legitimate interest in the data and it's not overridden by anything that protects the data subject's rights or interests. It has been said that you should be open about data collection to meet this first pillar, and it's got a simple test. No one whose data is collected should react with surprise if they are told, hey, we've been collecting your data. So a bit of a litmus test there, but if they look and say, well, of course, I saw signs all over the store, you're probably fine. Purpose limitation is really, to be simplistic, what it sounds like. Why are you collecting this data? What's the purpose for the collection of the data? Now, where it gets stickier is in the personal data being gathered for a purpose and only that purpose. So if I give permission for my data to be collected for a research project within a business, and then they decide they want to do a different bit of magic on my data, they have to come back to me and they have to say, is it okay if we use your data for this other thing that we didn't ask for permission to do? And I can say no. There are some other little pieces in here, and you can see, and I apologize if you're not actually watching, you have to basically lay things out. We want to collect your data for this reason. We're going to do it over this period of time. So 2 weeks to see how many people look at the bats flying out of the bridge area in Austin, Texas in February. That's it. If you decided you wanted to use the information you collected to see how many people were gathered and walked across the same bridge, you'd have to get new permissions. Data minimization. So again, this is a practical pillar that effectively says you really shouldn't be collecting data. And if you do, it should be the minimum amount needed for whatever it is you're trying to do. The actual statute, personal data shall be adequate, relevant, and limited to what is necessary in relation to the purpose for which the data is being collected and processed. There is a highlighted point, and it's with bold letters and it's italicized, and it says organizations cannot collect personal data for the possibility that it could be useful later on. That's an interesting one. What does that say about historical data that you've collected as part of a video surveillance system? A strict reading of this, where it says you can't collect personal data under the likelihood it could be useful later on. If you're storing surveillance video for a month against the possibility of something having happened during that month, or to prevent a slip and fall lawsuit or whatever, doesn't that directly contravene the third of the 4 written points on this particular slide? You cannot collect personal data for the possibility it could be useful later on. Now, you might read and say, well, hold on now, video surveillance is not personal data. And the actual answer is, yes, it is. Video data is personal data, because if I ran a facial recognition algorithm on it, I could find out who you are, and I could find out your name potentially. So it is personal data. So what does that say about retention times for video surveillance systems? It's interesting. Accuracy. So accuracy is fairly obvious, makes perfect sense if you're the guy writing it, maybe not so much if we're the ones trying to interpret it. They want you to be accurate and keep data up to date, relevant. Any inaccurate personal data should be deleted, right? You're supposed to review data that you have about individuals on a regular basis. And data subjects, you and me, have the right to request inaccurate data be erased. What is inaccurate data? Like laws everywhere, GDPR provides some very, very strong definitions on some things and potentially not as strong on others. In fairness, I am not a lawyer. I did not read chapter and verse on every bit of the GDPR, but rather just GDPR itself. And I am sure, or I hope, that somewhere in here, there's a greater and deeper dive on the definition of accurate. But if we just take the common sense approach, if I go on my credit report file in the United States and discover that I am being dinged for something that is supposed to be with a different person, I can go to the credit reporting agency, the TransUnion, and say, hey, that's wrong. Get it off my record. Common sense says this is basically the same thing. If a system has misidentified you, it says you're John Doe and you're actually Steve Doe, then you can go and say, that's not me, remove it. So it's a fairly obvious one. It makes you wonder if different member states, different GDPR signatory states, countries have run into problems with this, where inaccurate data has created really, really significant problems, like an unjust prison term for a person who is misidentified via facial recognition or something along those lines. Storage limitations. We should remember and try to tie this back to the comments earlier about video surveillance data. Personal data shall be kept in a form which permits identification of data subjects for no longer than is necessary for the purposes for which the personal data are processed. Personal data may be stored for longer periods insofar as the personal data will be processed solely for archiving purposes in the public interest. There's your get out of jail card. Scientific or historical research purposes or statistical purposes, subject to implementation of the appropriate technical and organizational measures required by the GDPR in order to safeguard the rights and freedoms of individuals. After you've collected the data, if you don't need it, you're supposed to toss it. And as I said under my breath a second ago, archiving purpose in the public interest. Well, common sense again rears its head and says, if I am maintaining video surveillance footage to protect my business against a lawsuit or to provide protection for the public using my facility, I assume or suppose that you could make an argument that video surveillance storage retention times are justified by public interest. Don't know that to be true or false, but it seems to be the loophole, the written loophole that would allow an organization to store video surveillance data. Integrity and confidentiality. This doesn't require a ton of discussion. Keep control of the data that you collect and records aplenty of the data you collect, and you keep it confidential. A lot of organizations covered by GDPR and about which I have read have found themselves suffering from heavy fines because of breaches and theft of data records, where the relevant regulators came in and said, look, you didn't provide a good enough protection for this information. So it's your fault that the data was hacked and stolen. So the onus is right and truly on the company that has collected the data to keep that data under solid lock and key and thereby protect it from a loss of confidentiality. Makes perfect sense. Accountability. Controller is responsible for and should demonstrate compliance with, just say, GDPR. So how do you do it? And this is, by the way, the last of the 7 principles. The accountability ideal here is you're taking responsibility for every part of data collection, from initial approvals all the way through the compliance and storage and protection. So, study current practices, establish a personal data inventory, ensure proper consent, perform data protection impact assessments, and quite possibly the most important one, creating a data protection officer for your business. GDPR is looking for companies to have someone who knows where the bodies are buried, who knows where the data is collected, where's it kept, show me the permissions, show me the information that's been collected. It's all in writing. It's an audit, and you have to be able to show all of this. So if your business is of a size great enough that there is a massive amount of this information, they're all but requiring the creation of a position within the company whose entire role is data protection, data management, audit, the whole 9 yards, an ISO 9000 position, if you will, within your own business. Moving on, who is covered by GDPR? There's a list on screen. It is all EU countries plus the European Economic Area, which is Iceland, Norway, and Liechtenstein. So it is all of the GDPR countries. I'm sorry. Stepping back. So GDPR covers all of the European Union countries. The major players you would already have known about, like France and England, but you've got Greece and you've got Estonia and Cyprus, Croatia, Portugal and Romania, Slovakia and Slovenia, Luxembourg, Malta, Latvia, even Hungary's in there. So all of these countries are signatories to GDPR, and GDPR protection covers an Englishman traveling in Greece, or someone from Croatia who decides to pop over to Portugal for a little beach vacation. How does this affect us in the US? Well, it's interesting. GDPR, of course, is going to apply if you have customers or users in the European Union, but how do you enforce it? So the idea here is, let's say that I am a company who is headquartered in New York City, and I've got, shops and whatever all over the US, and then I've got a half a dozen or a dozen in Europe, all in GDPR countries. When a member of a GDPR signatory country, a citizen, I should say, visits one of my shops in the US, they're covered under GDPR, and I am expected by law to protect their data in exactly the same way as I would if every bit of my operation was in an EU country. Again, I said headquartered in New York for a reason. Now, this actually makes it a little bit trickier because the businesses you have in a GDPR country could be affected through yanking of a business license, or you get hit with a fine that if you don't pay, they suspend your business license or whatever. So you have to be aware. Now, if there is a European, an Italian who's traveling to Orlando who goes into a small shop, no, of course not. Or even a major grocery store, no, because the US is not a signatory to GDPR. Are there exemptions? No. Pretty simply, no. Member states can have their own exemptions and rules and conditions as long as they don't really invalidate GDPR. But as you research GDPR, you find they have one exemption, which is if your business has under 250 people, you don't have to keep written records. Okay, that's about it. So, no, there aren't any real exemptions. Opportunities within GDPR. The opportunities for GDPR, and what I mean by opportunities are business opportunities, seems to be also pretty obvious. Whoever can start to deliver really, really relevant data that can be used by a business in a positive way, in an ethical way, but still used, and can deliver that information without any fear of violating GDPR, that's a good spot to be sitting in for sure. If you're in the United States, the opportunity exists today to understand what our neighbors across the pond are doing in GDPR, how they're enforcing it, how they're managing it, how the rules are being applied, and learn from it so that you can get yourself a step ahead of what is potentially coming. We are seeing this with CCPA, with the Illinois biometric laws, Washington, Utah, Virginia. Granted, most of our states have nothing regarding biometric video privacy laws, but some do. And the bigger question is it coming? Probably. No way to know for sure. But with the negative feedback and backlash surrounding Facebook, Twitter, all these social media sites, TikTok, sooner or later, this country and the citizens within are going to start having a harder look at data. And we certainly need to because as we're going to see and talk more about as we go forward, the deeper the dive into our own personal data, the more potential there is for misuse and manipulation. In the slide you probably can't see, we have business exemptions, opportunities, and threats. And threats is blank, and it's blank because we just don't know yet. Data protection and data privacy, again, still seems to revolve around the ones and zeros of driver's licenses and credit cards and social security numbers and whatnot in our country. The threat is a two-sided blade. If you're a business, the threat is that data protection laws will become onerous enough where your ability to collect, retain, and use data is going to be seriously and strictly, limited. For example, if you own a business that has a membership program and the person is a member of that program, and as a part of their membership, they have agreed, knowingly or otherwise, to complete use of their data. But if you don't have that kind of model and the laws become tougher and tougher, how are you going to live up to the letter of the law and the spirit of the law? And the answer is we don't know. From the individual side, the threat is your data and your ability to stay private and anonymous. There was a time in the United Kingdom, in London, where when you walk through the city, you would be photographed 70 times a day. Maybe it's more now, maybe it's less. And certainly the US has limited cities with that kind of coverage. It never bothered me because whenever I was in London, I wasn't there to commit a crime. So take my picture. I don't care. However, as again, we will talk about in later podcasts when we start to go into the scary and dark sides of some of these issues involving video biometrics and biometric data privacy. The more you know about me, the more possibilities there are for what you've learned and that knowledge to be used, I'll say, against me. And I don't mean that in a nefarious way, but while I don't mind being photographed, I'm not sure I would be so happy if I found out the photographs were being used to orient advertising towards me. I mean, hell's bells, I already get mad when I get AARP cards or credit card offers because I know they've gotten information from my credit bureaus that it's annoying, but all things being equal, I don't want it. And I certainly don't want a law enforcement agency to have me on their radar for something I am completely unaware of. So the threat goes both ways. Both the business and the individual have rights and responsibilities, and the business has an ethical obligation to do things a certain way. And we have a right to privacy. We have the right to the privacy of me, which is what this whole series is about. So everyone should be paying attention to what the potential threats are. There is one specific and I think wonderful example that both helps us understand more about GDPR and gives us a nice ramp into the horror of biometric data gone wrong, the usage gone wrong. Clearview AI. So Clearview AI is a US-based company, I think in Florida, but don't quote me, that spent 5 years, actually 6 to be fair, scraping the internet for pictures of people to be used in the training of facial recognition technologies, FRT as it is abbreviated. So let's take a minute and talk about Clearview AI. Clearview AI is a company based in the United States. Spent 6 years from 2017 to 2023 scraping the internet for images, pictures of people like you and me, which were then used in the training of facial recognition technologies. Now, sidestep. For those of you that don't know or understand, training an artificial intelligence to recognize a human face is really and truly an exercise in showing a computer algorithm, which is born as dumb as a box of rocks, in the recognition of a face by feeding it face after face after face, millions and then billions of these faces, until it can recognize a face on its own. That could be somewhat simplistic, and there are other issues with light skin versus dark skin and women versus men and whatever, but the point being, the AIs are born dumb, and they have to be taught a lot. The way you teach an AI how to recognize a face is what I said. You show it faces. So what Clearview did was they went out into the wider internet and just downloaded every picture they could find. Now, these images are classified by GDPR as something called image biometric data, video biometrics. So it's covered, it's sensitive data. And just because it's out on the web doesn't mean you're allowed to reuse it however you want. So Clearview, in collecting these images, collected them before GDPR, and then as GDPR got into signatory mode, etc., and has been hit with over 60 million euro in fines because of violations, none of which they've paid. Why have they not paid them? Because they're based in the US, and their argument is they're not responsible to maintain compliance with GDPR because they're not based in a GDPR country, and the US is not a signatory to the GDPR agreement. So Clearview is sitting on one side saying, well, we're allowed to do whatever the hell we want. And the European countries are, no, you're not. That's an enforcement issue. But for a wider perspective, think of this. Your face and my face and the faces of our children who might have posted on a website somewhere. And oh, by the way, you think, well, my child's stuff is private. Sure. But if they send it to someone who doesn't have a private site and it goes up, they could have been scraped, have that image downloaded and have it out on the wider web somewhere. We've all been used to help teach an AI to recognize a face. Yeah, okay. I mean, right, wrong, or indifferent, it sounds relatively benign. The one part of this that is not relatively benign, or there's actually many parts of it, but the one I'd like to focus on is the ability of companies like Clearview to also provide this type of information to companies and or law enforcement agencies who use you and your social media to get to someone else. We're going to take a much deeper dive into companies like Voyager and Palantir later. But Clearview is not the only company that has done this. Many companies have done this. And I would suggest the vast majority of them have done it with no nefarious intent. They don't really, they just want to teach their AI how to know the difference between a face and a brick. But there are those companies out there who take these pictures and collecting them from a social media site can use them to determine and create access to something or someone else. When does our right to privacy protect us from either being associated with something that is negative or criminal? And when does it give us protection against someone else using our connection to someone else against them? The law and order folks, and they're possessed of a good argument, believe that this is fine because it falls on the right of, public safety, et cetera, et cetera. But folks on the other side of that coin want to limit overreach by, policing agencies and governmental agencies, please visit the us-deepingsource.io site. There's a new blog post that has just come out in which we discuss some of the darker sides of this and hopefully provide something to think about. There's a scroll at the bottom of this webcast, and I'll put it into the podcast show notes to link directly to this blog. But I would encourage you to go download it and have a look. If you're a member of our LinkedIn newsletter group, you can go to it from there. It'll be the same information. Your data, and this illustrates again why things like Clearview should concern you. The ability to use your data in ways you have not thought of is astounding. We all have been on Google looking for what's the last birthday present you bought a friend or loved one or child or sibling or whatever. For me, I was looking for Henley shirts. So you go on Google and type in best men's Henley shirts, and what's all over your Facebook feed the next minute, or in LinkedIn or whatever? If I type in to Google best guitar equalizer, my LinkedIn feed is filled with plugins for that. That's not nefarious. In some cases, it can be kind of helpful. But the line between helpful and annoying and nefarious is so gray. And we all, I'm sure, realize that chasing the dollar widens the gray area, doesn't shrink it. Have a look at the blog post. It's fascinating. Let's roll back to a conclusion on this whole discussion about GDPR, which is really less of a discussion today and will become more of one as we move on down the podcast road. What we're seeing happen in countries covered by GDPR is a recognition of data overreach and a response that requires companies to either justify their data overreach or usage, or don't do it at all. How much of this is open to interpretation is a country by country question. And neither GDPR nor any of the US counterparts, similar laws and regulations, can possibly know what kind of things are coming. I think GDPR does a pretty good job of guessing, because it talks about gait analysis and some other things. But can we stay ahead of the technological advances? And does GDPR give us as business owners the opportunity to get ahead of potentially dangerous liabilities going forward? That might be the most important thing if you're a business owner and you happen to be listening and following along with what's happening in data privacy in GDPR areas, is as we sit in our city and state in the United States, we can look at what's happening and we can get in front of it. And more importantly, we can publicly get in front of it, and we can be advocates for the moral and ethical use of collected data. The data collection is underway every single day, and we know it's out there. And to some extent, maybe that cat is way out of the bag. But again, in the state in which you live, if and when that state passes a data protection law that is hardcore and includes biometrics and includes video biometrics, et cetera, is your business prepared? And do you know what's coming or what could come so that you are preparing before it gets here? So go find GDPR online and go look at it. If you're in a larger company, talk to legal people about it. And if you're an individual concerned with data privacy, get our newsletter or get someone's newsletter and learn as much as you can about it, so that you can make sure you're protecting yourself and people around you from objectionable use of personal and private information. I'm Scott Saraboff with Deeping Source. Next time on Privacy of Me, we're going to be taking a walk down the horror show lane of data privacy and video biometrics. And until then, this has been the Privacy of Me.